Welcome to another episode of Talking Legal with Templars. My name is Femi Oyewole. I'm a partner in the dispute resolution practice group at Templars. I'm here with my colleague today, Orji. Orji is a managing counsel in our dispute resolution and international arbitration practice group. Welcome, Orji.
Thank you, Femi. Thank you for having me.
My pleasure. Today we'll be discussing the concept of the defense of sovereign immunity vis-a-vis the enforcement of foreign arbitral awards. This is an interesting subject given that countries in recent times have tried to portray themselves as arbitration-friendly states. For example, in 2023, Nigeria passed the Arbitration and Mediation Act in a bid to portray itself as an arbitration-friendly state. However, when it comes to the enforcement of arbitral awards, these same states play up the defense of sovereign immunity. So it's important that we delve into this subject to understand the interplay between the defense of sovereign immunity and the enforcement of an arbitral award. As a preliminary point, can you talk us through the process of enforcement of a foreign arbitral award?
So I think the best place to start is to mention that there's an international instrument known as the New York Convention. The long name is the Convention for the Recognition and Enforcement of Foreign Arbitral Awards, 1958. That instrument essentially sets out a mechanism, a very streamlined mechanism to enforce foreign awards. The good thing about the mechanism is that once you are a member state to the convention, it's possible to enforce your award in any of the 173 member states of the convention. And Nigeria is one of those states. Nigeria, I believe it was in 1970 that Nigeria ratified the convention. And because of the number of member states, it is one of the most universally accepted conventions. In very simple terms, what the convention does is it provides an easy mechanism to enforce an award. And as you already mentioned, Nigeria also has the Arbitration and Mediation Act, which essentially domesticates and reproduces the provisions of the convention. The mechanism is simple. All you need to do is once you have an award, you take that award together with the copy of the arbitration agreements to a court in a state. And that court would have no other option but to enforce the award, except in very limited circumstances where there are vitiating elements, and about 7 in number. Other than that, each member state has a duty, an obligation to enforce the award.
Okay, so thank you for that, right? So what then is the concept of sovereign immunity?
Okay, so on the other hand, sovereign immunity is essentially a defense available to, as the name implies, sovereigns.
Okay.
So in time past, it used to be available to monarchs, kings, in kingdoms, empires. But today, we have what we have are countries. So those countries, or states as we call them in international law, have immunity. What it simply just means is that a sovereign state cannot be commanded, cannot be mandated to appear before a court or tribunal in another state. When you do that, you breach the immunity right. It's a right that is available under what you call customary international law to every sovereign state.
Thank you for that, Orji. This immunity that you've spoken about, is it absolute?
Oh yeah, so in time past, it used to be absolute. Simply being a sovereign means you could not be sued. You couldn't be taken to arbitration before any tribunal. But it became clear with the passage of time that states were taking advantage of the immunity doctrine.
When you say states, sir, do you mean like Abia?
No, I'm not talking about Abia or Osun State or Lagos State. I'm talking about states like sovereign states, so countries, basically Nigeria, Ghana, US, as the case may be. So those states were taking advantage of that immunity doctrine in the sense that because they are sovereign, either they or their agencies would enter into transactions. They wouldn't pay, and when they are sued, they turn around and claim immunity. So to stop that, a new concept then develops. So there's now a move away from total immunity to restrictive immunity. So it's a function of what the nature of the acts carried out by the sovereign states. So if you carry out what is essentially a sovereign act, you have immunity. But if what you are doing is in effect a commercial activity, then no, you don't have immunity.
Okay, you can no longer waive the tag of immunity.
You can exactly, and you can be sued.
Okay, so where is this immunity, this sovereign immunity, where is it derived from?
So basically, it's a function of customary international law, practice of state. Most states have over time given effect to it, so it has become part of customary international law. In some other countries, let's say in the US, they have their Federal Sovereign Immunities Acts, 1976. The UK also has the Sovereign Immunity Act, 1978. Nigeria does not have Sovereign Immunities Acts. We have immunity in the Constitution for President and Governor of a state. We have diplomatic immunity. We have an act for that, yeah. But we don't have a Sovereign Immunity Act. Instead, it is derived from, as I mentioned earlier, customary international law, or what obtains under the common law, because it's part of Nigerian law.
Are there other countries who have something codified in terms of their own sources of...
Just the example I mentioned, the UK and the US, they have their sovereign immunity.
But Nigeria doesn't have anything like that.
Doesn't have,
Okay, so this concept of sovereign immunity, at what stage can I raise it as a sovereign?
Yeah, so there are two principal stages at which sovereign immunity is raised. The first stage is the stage of jurisdiction. In other words, where a claim is brought against you before an arbitral tribunal. At that stage, as a sovereign state, you would say, I have immunity. So that's the first stage. But in practice, that hardly ever happens because most business persons who are entering into contract with states will always insist that the states must expressly waive their right to immunity or expressly enter into an arbitration agreement. That amounts to a waiver of sovereign immunity. So states don't typically raise it. The stage at which they raise is the second stage. That's the stage of enforcement. Because it's one thing to get an award, it's another thing to have the award enforced. So it's at the stage where you seek to enforce an award that the state then comes up and says, oh, I'm sorry, I have immunity, and so you cannot seize my assets for purpose of enforcement of your award.
Thank you for that, Orji. But let me understand. So is there a need for further consents for enforcement?
Oh, absolutely. Absolutely. You know, as I said earlier, there are two different stages. So on one hand, the fact that a state has given you consent at the stage of jurisdiction does not mean they have also given you consent at the stage of enforcement. Okay. The duty on the part of a state, when they enter into agreement to arbitrate, is that they will do everything possible in furtherance of the arbitration. Yeah. And English courts have held that includes an application to recognize and enforce an award. But when it goes to the extent of trying to seize the assets of a state, you need an extra consent for that stage. Now, except you can demonstrate what is called the commercial purpose exception. What that simply means is that if you don't get the consent of the state, but you can demonstrate to a court that the asset or property that you seek to seize is used or intended to be used for commercial purposes, only then can you seize the assets. If not, you have to get consent.
Fantastic. So just to drive the points home, just to bring the points home. So has Nigeria ever raised the defense of sovereign immunity? And if so, what was the outcome?
It's interesting you ask. Nigeria almost always raises the defense of sovereign immunity. In fact, anytime you have an award against Nigeria and you try to enforce it, they always raise the defense of sovereign immunity. Now, I'll give you two examples, both from the same country and two different outcomes. There's an avionics and Nigeria case in the UK where the asset sought to be seized belonged to the Nigerian High Commission in London. It turned out that the property had been leased by the High Commission to a third party for use for the production of international passport, data capturing international passports. Now, when they tried to seize the asset, Nigeria raised sovereign immunity defense. And the award creditor argued on the contrary, that what they were carrying out was clearly a commercial activity. But the court agreed with Nigeria and held that even though there was some element of commercial activity, in actual sense, what they were carrying out was a consular service on behalf of Nigeria High Commission. As a result of that, that defense of sovereign immunity succeeded, and they could not succeed in seizing Nigeria's assets. Okay. Now, on the contrary, this is a second case, Zhongshan, Fucheng, and Nigeria, 2024. In that case, similar property belonging to Nigeria, or Nigeria High Commission in Liverpool, two different properties. What happened was Nigeria had also leased them out to third parties, but they were leased out to private individuals who were not Nigerians, and they were not carrying out any consular service. So when Nigeria raised a defense to say that those properties were also properties belonging to the sovereign state of Nigeria and could not be seized, they were able to succeed. I'm talking about our creditor. They went to the extent of going to the property, interviewing the tenants there, and found out that they were not Nigerians, they had nothing to do with Nigeria, and they were not providing any service to Nigeria. As a result of that, that defense of sovereign immunity failed, and those two properties were seized and given over to the award creditor. So these are two examples. There are many other examples where Nigeria has raised the defense and partially succeeded. In other cases, they didn't succeed. Okay,
I think in the latter case, I recall you wrote an article about it sometime last year.
Yes, but for something different, because, you know, the money in question was about $70 million. Okay. So they had tried to enforce the award in different places. Okay. One of the things they also did was to go to France and try to seize Nigeria's asset. And in fact, at the point, they succeeded on the interim basis, seizing 3 of Nigeria's aircraft. But I think they ultimately settled it because the property was given back to Nigeria. But it is possible, it would have been possible for them to seize it depending on the purpose for which the jets were being used.
That brings me to my next question. So is it possible to seize, for example, a presidential jet? And are there examples where this has been done?
Yes and no. As I say, it's just a function of if you can demonstrate the purpose. Now, there's an interesting case, Comiplex and DRC, the Democratic Republic of Congo. In that case, the jet of the president or the presidency was seized because the award creditor was able to demonstrate using the manifest of the jets that they were using it for commercial activities. If not, he wouldn't have been able to succeed. The French court in that case, after listening to them, agreed that the purpose for which they were using the jet was a commercial purpose, not sovereign purpose. So it's a function of what you can demonstrate. The burden of proof is high, but if you want to get it, first you must put in the work. So in that case, it succeeded. In many other cases, it's difficult because you have to demonstrate, as I said earlier, the purpose for which property was used. Yeah.
Okay, so what will be your final words? If you're trying to balance the interplay between being a sovereign with immunity and also being able to enforce an arbitral award against a sovereign?
I think you put it perfectly at the beginning when you talk about that tension that exists between, on one hand, the need for a sovereign state to exercise its sovereignty, but on the other hand, too, the need to be seen as being arbitration friendly because you want investors to think that your country is open for business. So I won't say state shouldn't raise immunity defense, but I do know that any right-thinking investor or any right-thinking business person will enter into a contract with a state without asking for express waiver of immunity. But the mistake that most people make is that they only ask for immunity to bring the claim. They don't ask for express waiver of immunity to raise the defense of sovereign immunity at the stage of enforcement. So that's where people need to place emphasis going forward, that you still need that consent. And if you don't get it at the beginning, when the dispute has arisen, it will be more difficult and the burden of proof on you will be very high. The other thing is, if you have gone into it already, you have to make sure that you have very good lawyers doing your case for you, because you can see the extent to which the lawyers went in Zhongshan to prove that those properties were used for commercial purposes. So once you have your good lawyers on your side, I'm sure it's easy for you. Then for the states, they have to decide at one point what they want to do. Do you want to be seen as arbitration friendly, or do you want to exercise your right as a sovereign state?
Thank you very much, Orji. Thank you very much for that. We've learned now that the issue of jurisdiction as a sovereign and the issue of immunity can be raised at any point in time. You can either raise it during the proceedings. You can also raise it at the point of enforcement of an award. As investors, as you do business with sovereigns, you must make sure that you obtain consent at the enforcement, because ultimately the entire point of resolving any dispute is able to attach assets and fulfill whatever award you've gotten. Thank you very much for your time, Orji. This has been Talking Legal with Templars. Thank you.